Hello and welcome to IB Times TV. I'm Lianna Brinded, Senior Business Journalist for the International Business Times. Joining me now is Abhishek Sachdev. He's a Managing Director at Vedanta Hedging. Hi Abhishek.
Hi Lianna.
Hi, well thanks for joining us. We've got a quite big topic that we're covering, the mis-selling derivative scandal. So maybe in a nutshell you can tell us, describe the scope and scale of this and how important it is to the rest of the UK.
Well, I think that derivatives are causing one of the largest issues in the whole UK property market in the country, right from very small businesses who are involved in this scandal, as it were, and then also to the very large businesses who have hundreds of millions of pounds of debt.
Sure. And maybe to people who are watching this that don't quite understand what an interest rate swap agreement is, which is one of the products that most of these businesses have been sold or missold, maybe you can have a description about that.
Sure. In really simple terms, an interest rate swap is essentially it's a separate product which you combine with a loan, and it essentially turns the loan into a fixed rate. So it provides absolute certainty to the small business of what their interest costs are going to be on a monthly basis going forward. So essentially it's like similar to like a fixed rate mortgage, in the sense that you have absolute certainty what your interest costs are going to be and you're protected from interest rates going upwards, but obviously you can't benefit if interest rates fall.
Sure, and for the businesses who have these though, why have these products had such a detrimental impact to the way they live life and do business now?
Yeah, I mean it's quite a complicated question, but what the regulators found, which we'll come on to, is a lot of these businesses haven't really understood the consequences of entering into these agreements, because they are derivatives, and although the actual mechanics and the underlying features of them can be quite complicated, and as a result a lot of small businesses who may want to try and get out of them having to unwind these derivatives, and because interest rates are so low, the cost of doing so for so many small businesses is prohibitive.
How have you seen this affect them? I've heard that some unfortunately have gone out of business, but what has been the widespread problem for them?
For some businesses it's pushed them over the edge. Some have already gone into administration, liquidation. We unfortunately have a client who potentially may have even contributed to them passing away due to the stress which the family said the individual suffered. But there are so many small businesses who would be able to invest in their business and would love to grow and develop their business, but they can't because they're hamstrung by having these products in situ.
Okay, so this situation has obviously evolved over the last few years, but when did it become apparent to you that it was a huge problem that needed to be tackled?
Absolutely. Well, I think the banks started to seeing these complaints when interest rates began to fall, which was late 2008 and early 2009, because small businesses started saying, well, actually, what are these payments leaving my account every month? I don't understand what's going on. So we started seeing this, in 2011, in terms of raising the awareness of this. Until then, businesses had been writing complaints to their banks, and the banks had just been ignoring them. And it wasn't until we gave information about this to the Telegraph and the FSA then started looking at this, did this become into a widespread national investigation, as it were.
Sure, I mean that's a key milestone actually in this whole situation, is the FSA review that came out in the summer of last year. Can you tell me a bit about your initial reaction to when it came out, and then maybe the concerns that have arisen since then?
Yeah, sure. So the FSA started looking at this after the Telegraph started reporting on this. And then on the 29th of June 2012, the FSA said that they found some systemic mis-selling from the main 4 UK banks. At that stage, they didn't really start proposing what the recommendations and things would be. What's happened since then, and there was an update just a couple of months ago on 31st of January, saying that the FSA had found potentially 90% of these things that they'd looked at already had been mis-sold. But the problem is the challenge the FSA has faced is that each of these products has to be looked at individually. There's no sort of one-size-fits-all redress policy which the FSA can simply issue, like you can with PPI mis-selling, for example. So these things have to be looked at individually, and it is difficult because the circumstances are unique. So, for example, some businesses are asking for all of the money they've ever paid on a derivative to be refunded back to them, the break cost to be waived, and some consequential losses to be paid to them as well. And the FSA has said that in certain cases they will allow that to happen. The question is, in which cases will that be permitted and which ones will it not?
Exactly, we're in limbo at the moment because with the findings from the pilot scheme, we're still waiting to get some examples of what redress is going to look like. What would you say are the options that are out there in terms of the banks being able to grant redress? Because, like you said, a lot of other simple products like PPR have been straight refunds and a little bit of compensation. How does that differ with mis-selling derivatives?
Again, it depends on, and this is why it's unique, because the FSA's review has sort of focused more on products, where actually we believe with Vedanta, this is more about the sales process. There's no such thing as a good or bad derivative as such. It's more about, is it appropriate, has it been explained properly? Because derivatives can be appropriate in the right circumstances. And just for example, just this morning we were talking to one of the largest food manufacturers in the country who has exposures in currencies across the globe, and they're using currency derivatives to help manage that risk, as is appropriate for them to do so. So in terms of what possible redress options should be given, it's more about looking at how was a product advised, was it appropriate to them, maybe some sort of protection was appropriate, and an alternative product, could be looked at. But again, it depends on which one, because some products could still leave the small businesses with very large costs. Whereas there are some products like caps, for example, where for a relatively small premium, the business could have had protection and never had any liability. In other cases, the SMEs will be asking for all of the money they've paid to be refunded back to them. So it does very much depend on a case-by-case basis.
After the scheme and after the review and the scheme, obviously there's been concerns arising out of that. But actually, there's been a lot of stir, I suppose, especially in Parliament recently, about maybe some of the methods that the banks are using to fact find or to look into the cases to maybe even just verify information. Are there any concerning maybe behaviours that you would say that really need to be looked at?
Yeah, and again, this is the challenge the FSA's had. The FSA is still, or the FCA as it's soon going to be, doesn't have the resource to be able to monitor and sit in on all these reviews across the country, not if you've got 40 or 100,000 small businesses. So they've asked the banks and then generally the big four accountancy firms to sort of sit there and police and monitor these things on their behalf. And unfortunately, you are going to see inconsistency across, it's human nature to see inconsistency across different parts of the country and different meetings. For example, we've been in some meetings where the questioning's been quite interrogative, and the SME hasn't had all the information there in front of them because it's happened 5-6 years ago. They don't obviously have a great recollection, and yet the bank is very well prepared and asking some pretty tough questions to the SME, and almost feels like a cross-examination. So these things will be ironed out, I think, going forward, but it is one of the challenges the FSA has.
Sure. I mean, the FSA, as you've detailed, has had a lot of challenges in terms of trying to make this as fair as possible for banks to look into these cases and for the businesses. But overall, the underlying theme seems to be that the banks have too much power. Would you agree with that?
I think we have to take into context that the cost of this issue is likely to be in the very significant billions, as Tessa Munt MP said the other day to yourself. So far, the banks have, I think, set aside probably a total of £2 billion for this provisions. We said on Sky News a couple of months ago, we think it could be as high as £20 billion, especially if you start taking into account the legal settlements as well. So naturally, the banks are going to try to, and their shareholders, of which obviously the taxpayer is involved in that too, is going to naturally want to minimise the amount of payouts that they want to do. So it is going to be difficult. And at the same time, the FSA can't just go into the individual situation and say this is what you need to do, like it can do with an IFA, for example, because the scale of this issue is so large. So I think the FSA has found a balance of trying to get independent assessors in there, but it just needs to be policed going forward. I think one of the most important things the FSA should do in this process is actually set up a proper appeals process. Because so far they've said if a business is not happy with the review, then all they can do is either try the legal remedy, but that may not be possible if it's gone past the 6-year sort of statute of limitations, or they can go to the financial ombudsman. But the financial ombudsman is by definition only for very small micro businesses. So for a lot of SMEs, that's not going to be an option.
Picking up on the legal process, that's another route, I suppose, that's been running alongside the review. And as he picked up on, the statute of limitations is 6 years. So a lot of people, without having this deadline to hear back from the banks on, are getting worried that by the time they do get a result, that it could lead to, a diminishment, I suppose, in their legal rights. What would you say has been happening behind the scenes on the legal side?
I mean, firstly, on the legal front, businesses have been taking legal action for, I think 3 or 4 years, actually. We've been working with clients for some years on this, and a lot of our, clients have achieved settlements, on that basis, but these are all on a confidential basis. And typically they involving some sort of, expert analysis, a solicitor and a barrister who then start, coordinating with the bank. But the problem is that the statute of limitations means that if you've entered into these things more than 6 years ago, it makes it very difficult, if not impossible, to actually start making a claim against the bank. And we've actually got some examples of businesses who were part of the FSA review process, according to the criteria set out on the 29th of June, and they were still within their 6-year period at that point. On the 31st of January, just a couple of months ago, the FSA's changed its criteria for who's eligible for the scheme, and now they're no longer part of the scheme because of the new sophistication criteria. But actually now they've gone past their 6-year statute of limitations. So they're not part of the FSA review scheme and they can't take legal action. So actually they have no route of redress available.
Well, we are in limbo at the moment, waiting to get some of these examples back. But in the meantime, I suppose, what would you say would be some recommendations? You picked up on it a bit earlier, but some more recommendations that can make tweaks to maybe the FSA review that would make it more clear, maybe?
So I think the FSA could quite quickly just simply put some sort of appeals process in place where the FSA almost grandfathers some of these, sits on some sort of appeals panel for looking at some of these cases. Obviously the work could still be done by another independent assessor, like another Big Four accountancy firm, for example. So that could be something the FSA, I think, could do quite quickly, and it wouldn't be that expensive. Well, the banks would have to pay for it anyway. But in terms of what should small businesses do, they should make sure that they only seek, proper qualified specialist advice. There are, unfortunately, dozens of claims management companies springing up, the same companies who are texting and calling people for PPI claims, and now on their same website doing, swap mis-selling. And it's absurd that, these claims management companies think that they have the expertise to understand these products. So we'd urge small businesses to make sure that they speak to a solicitor or financial experts who are FSA authorised, who understand these products. And when you're speaking to a solicitor, make sure they properly understand these products. Otherwise, as we've seen in some cases, if you take a poorly argued case against the bank will let it go to court, and you'll lose if you don't present the case properly.
Sure, and I suppose to round up, again, we picked on it a little bit before, but in terms of the scope and scale of this scandal, do you think the amount that the banks have set aside already is enough?
No, I mean, the banks have probably set aside, I think, a total of about £2 billion. Initially, they, before the FSA scheme said anything, they were saying this is not an issue. Subsequently, they've still sort of saying it's not an issue, and that they've drip-fed kind of the provisions as they've been used to doing for PPI, for example. But the amount they've set aside, I think, is paltry compared to what they ultimately will be paying, purely because the size of the claims are still so significant. We have clients that we're acting for who have debt of £600 million, for example. Now, sure, they're not part of the FSA review scheme and they're not someone who the media is going to have much interest in, but they still do not believe they understood the derivatives that they were advised to go into. So the cost of settling these claims out of court is still going to be in the billions of pounds. We said, on Sky News a couple of months ago that we think it could be as high as £20 billion if you take into account the review scheme plus all of the settlements that are going on behind the scenes.
Okay, well, thank you very much for joining us.
No problem, Lianna, thank you.
And that was Abhishek Sachdev, Managing Director at Vedanta Hedging.